Hello everyone and welcome to an Employsure webinar. Today's discussion is on workplace compliance for P&Cs in Queensland. We are pleased to welcome our presenter for today, Scott Nicholson. This webinar is live and interactive. You are encouraged to post questions to the presenter throughout the presentation. If you're experiencing any technical issues during the webinar, please dial our support team on 1-800-733-416. This number is also listed in the chat box. I'd now like to pass you over to Cheyenne to begin.
Thank you very much and welcome everybody to our webinar today. As you know, Employsure since this year have been providing support services to P&C and the schools throughout Queensland with regard to HR matters, and as part of that we see education as being very important so that we can help you build up your knowledge and understanding of how HR works, legislation, consequences and so on. And that's why we're running the webinar today. So it'll go for around about an hour. It'll be run by Scott Nicholson, who's one of our field consultants. He's one of the people in Employsure who help our clients set up their documentation. So he's well versed in the legislation and how it affects you. We'll also be announcing some new pricing for our P&C clients, which I'll be doing at the end of the seminar. We'll be taking questions at the end, so you can type those questions into the chat box, and we'll hopefully get through them all throughout the webinar. So, Scott, if you'd like to take over, and then we can go from there.
Thanks for that, Sean. Hi everyone, my name is Scott Nicholson. I've been an employment relations advisor at Employsure for the last 2 years. My role at Employsure is to help guide businesses through Australia's extremely complex and difficult to follow and difficult to understand employment legislation so that we can minimise risks and to ensure those businesses are fair and safe. Today I'm going to be talking about kind of the ins and outs of workplace compliance and how to avoid workplace claims. Specifically targeted through the Queensland system and for Queensland P&Cs. So, to start off with, we'll give you a bit of a background to kind of the Queensland state system. So, generally speaking, the Fair Work Act, the national system, applies to most employers and employees in Queensland. However, some businesses and some organisations would be covered by the Industrial Relations Act, which is completely separate to the Fair Work Act. So basically, these businesses, the businesses that would be covered, are businesses that are associated with the public sector, so state government or local government. So these can be things like correctional facilities, law enforcement, public hospitals, fire and rescue, and also, in this instance, public schools. So connection to public schools, obviously the parents and the P&C committees. What that means, though, is it's a completely different system. However, these systems are kind of intertwined and a little bit related in a way that have very similar wording in it, but they will be dealt with by different commissions. So the Queensland Industrial Relations Commission will be taking over any sort of issue that can arise through employment instead of the Fair Work Commission. And so, therefore, any dispute, any issue that can arise during an employee's employment would be dealt with by that commission. You would also be covered by the P&C Industry Award 2016. That's going to set out a few additional terms and conditions of their employee's employment. It's going to sit on top of the Industrial Relations Act. So, to start off with, we'll kind of talk about the leave entitlements that employees are entitled to under both the Queensland system and under the P&C state award. So first and foremost, annual leave. These leave entitlements under the Queensland system are pretty similar to the national system. Employees are entitled to 4 weeks paid annual leave. They get the only difference between this and the national system is that these employees are required to receive a 17.5% leave loading, and this annual leave doesn't apply to school-based apprentices and trainees. To be quite honest with you, though, it doesn't often come up through Queensland P&C that you'd have school-based apprentices or trainees, but sometimes on rare occasions it does. So it's important to know that. It's the same with sick leave as well. So sick leave, you get 10 days, unless you're a casual, you get 10 days of sick or carers leave on full pay. But this also doesn't apply to school-based apprentices and trainees. You get sick leave when an employee is unfit for work due to an illness or injury. Basically, what they'll need to be doing is bringing in a medical certificate there. There's also a connection there as well with compassionate leave. So the Fair Work Act also has compassionate leave, but in the Queensland state system, there's a few extra rules regarding that. So you get 2 days of paid compassionate leave unless you're a casual. If an employee's immediate family member or household member passes away. But the main difference here is that if a pregnancy ends due to basically a miscarriage, an employee will also receive compassionate leave. There's a slight difference in that respect as well. You can also request that they bring in evidence, but it's one of those issues. It can be a little bit more of a touchy subject. So you got to weigh up the need for evidence with kind of HR requirements of the business. One of the major differences between this act and the national system is cultural leave. So employees who is required by Aboriginal traditional custom to attend any sort of Aboriginal ceremony can take up to 5 days a year unpaid as cultural leave. And there's also another big difference. This one's a paid leave, so domestic and family violence leave. So employees other than casual employees are entitled to 10 days domestic and family violence leave on full pay if they experience domestic violence. You can request, and often you should be requesting that you can get evidence for this. These can include things like medical certificates, police reports, and things along those lines. It's one of those touchy subjects once again, but if you follow the correct HR processes, you can get away with executing it in line with policies, and you can get away with making employees happy. So another type of leave, and we'll just gloss over these ones, parental leave. You get up to 52 weeks of unpaid parental leave and maternity leave, and long service leave. So if an employee has completed 10 years of service, they get 8 2/3 of a week of paid long service leave. That's essentially 2 months worth of long service leave. They can also be entitled to long service leave if they resign or if they are terminated between the years of 7 and 10 of their continuous service. So that's something to keep in mind, that they may also be entitled to pro rata leave. Also, they can receive emergency services leave. So if they're part of the SES or if they're volunteering in that kind of respect, they can also receive unpaid leave for that, and jury service leave. So you would have to basically pay the difference between the employee's rate of pay and what the government's paying the employee to attend jury service, and that's going to be for the extent of their jury service. So they're the major types of leave. Once we've got those out of the way, we'd have to have a look at other aspects that can kind of that employees could incur during their employment. So I've got a question for the people in the audience. These are just true or false questions. I want to know what your answers are to this, and everyone's going to have different opinions, of course. Just feel free to put it in the chat. Firstly, true or false? You need 3 warnings before you can terminate employees. What's everyone's thoughts? A lot of people are saying false. It's kind of true. It's kind of true. What you'd be looking at here, there's no magic number with how many warnings you can give an employee. When we look at different things, there could be very minor issues that they've been facing. It could be over an extended period of time. We'd always have to judge it on a case-by-case basis. For example, if an employee robbed your workplace and set the place on fire, you don't need 3 warnings for that. You could probably terminate them if you give them a due process with summary dismissal. If an employee is late by 2 minutes and they do it 1 year and then a year later they're late by 2 minutes again and a year later they're late by 2 minutes again, it's probably going to be unfair if you terminate them on the back of that. So yeah, you're quite right. It's going to be dependent on the circumstances. I kind of touched on this earlier, but you can terminate someone on the spot for serious misconduct. What are your thoughts there? A lot of people are saying true. It's true, but with a caveat. So you wouldn't be able to terminate someone necessarily on the spot. You'll still need to follow the correct process to go ahead and terminate the employee. That's something that's outlined in the Industrial Relations Act. You need to provide them with the correct type of meeting, and you need to provide them with basically an opportunity to respond. So what that's going to entail, even if the employee has done the absolute worst thing in the entire world, if they've kind of destroyed all of the company property on purpose, stole from the company, and basically ruined your entire business, they could still potentially make an unfair dismissal claim if you just said you're terminated. What you would need to be doing, as ridiculous as it sounds, what you need to be doing is inviting the employee into a meeting to allow them an opportunity to respond. So you'd be saying, inviting them into a meeting, suspend them for 24 hours on pay, invite them into a meeting and get them to respond to these allegations, get their side of the story before we can go ahead and terminate them. It is one of those cases where you could terminate them without paying notice. I'm going to touch on that a little bit later. But it's one of those issues that can be a little bit contentious, but we still need to follow the correct process. Next question. If an employee does not hit KPIs, you can terminate them. What are your thoughts there? So, bit of mixed, true, false, true-ish. Yeah, I mean, that's exactly right. That's exactly right. It's true-ish, as with all of these. If they're not hitting their KPIs, as I kind of touched on previously, you really need to be making sure that you follow the correct process. You need to give the employees an opportunity to get better. If, for instance, they've been with a company for longer than their probation period, and they could make an unfair dismissal claim, what we need to do is allow them an opportunity to get better, clearly set out what their KPIs are, and review them on a regular basis to see if they're hitting them. So you'd be setting, for instance, a month, say you need to hit these KPIs, you need to make these amount of sales in this month, otherwise we're going to give you a written warning. And then after that, do the exact same thing, written warning, making sure that it's fair, it's objective, and it's realistic, and within a time frame. But yeah, eventually you could terminate them if they are consistently not hitting those KPIs and you're following the correct process. And finally, it's an interesting one. Can you terminate someone via text? So it's an interesting one. I really hope not, is one of the answers. But essentially you could. There's no legislation that's restricting you from terminating someone via text message. It's a bit of a difficult one. It's very poor form in the eyes of a lot of employees, and I'd recommend against it normally because it normally spurs employees on to make some sort of claim against the business after, leaves them with a bit of a sour taste. But technically speaking, there is no legislation against them, against terminating an employee via text. So now that we've got that down, we kind of touched on a few issues with termination. We'll touch on notice, because notice is a big thing that's different between the Fair Work Act and the Queensland state system. Notice isn't payable to casual employees. That's the same as the Fair Work Act. Notice isn't payable to employees engaged by the hour or by the day, which is a specific arrangement that can be done under the Industrial Relations Act. Notice isn't payable to employees on a specific task or a period, but here's where it starts getting a little bit more different. So notice isn't payable to employees during the first 3 months of their employment. So this is known as the probationary period under the Industrial Relations Act. So you wouldn't pay notice in that 3 months unless you agree in writing before they start that the employee either serves a shorter probation period, so 1 month, whatever it would be, or they don't have any sort of probation period at all. So if you've specified in a contract that they don't have any probation period, then the employee could say that they are entitled to notice if you terminate them during that time frame. Also, employees participating in labour market programs would also not receive notice periods. I kind of touched on this a little bit earlier. If we're terminating an employee due to serious misconduct and we've followed the correct procedures to terminate them, we wouldn't need to be providing them with notice. Keeping in mind that serious misconduct has a really high threshold to meet. These are things like theft, these are things like fraud, assault, coming to work visibly intoxicated. Those types of situations are where we could potentially, if the employee's doing it willfully and deliberately, we could potentially terminate them without any notice period. So, finally, another interesting aspect of the Industrial Relations Act is that employers need to provide an employee with a statement of service after termination if the employer requests it. So it's a legal requirement to do that. So protection from unfair dismissal claims. This is a really interesting one, and I've kind of went over it a little bit previously. But in the Queensland state system, we need to work out two things in particular. When an employee is going to the commission for an unfair dismissal claim, we need to work out two things. One, was it for a valid reason? Was the employee dismissed to start off with for a valid reason, such as poor performance, misconduct, redundancies, things like capabilities, if they're physically incapable of doing it anymore? Was that a valid reason? And two, the process. So if you're not following the correct process, no matter what they've done wrong, you could still be pinged with an unfair dismissal claim. And these claims can be up to a maximum of 6 months worth of pay. So that's quite a lot of pay for most employers, and so you've got to be very careful about what we do in that respect to try and mitigate those types of issues. Employees, keeping in mind, employees only have 21 days from the dismissal to make a claim to the commission. And when that happens, basically we would have to prove that we terminated an employee due to a valid reason, so consistent poor performance or engaging in serious misconduct or engaging in repeated acts of misconduct, and we terminated it off an escalation of written warnings. But we'd also have to show that on each and every time we gave a written warning, that was a fair process. So it's a pretty interesting one, and it can be very, very complex, especially when you look into things like a genuine redundancy and things like capabilities dismissal. If an employee is permanently sick or unfit for work, it becomes a really touchy, really difficult situation when trying to terminate their employment. Another aspect that's a state-based issue, another thing to take into consideration, is preventing workplace bullying. So the Anti-Discrimination Act is a state-based act in Queensland, and all Queensland employers are going to be covered by that. As an employer, you're obliged to take the steps to prevent or minimise the risks of bullying and harassment at work. The financial cost of bullying in Australia is up to $13 billion a year. That's not necessarily just from claims to the Anti-Discrimination Commission in Queensland. That also comes from claims to work health and safety, so workers' compensation claims. That's the biggest one that I see. As an advisor, I see that all the time. People rarely would go to the Anti-Discrimination Commission. The first thing that they'll try and do is just make a workers' comp claim. It's really common that employees will say, I'm too stressed to go to work, I can't physically go to work because of this bullying and harassment that's going on. And so it's really important that we set out clear bullying and harassment policies, and if it's practical, we can offer bullying and harassment training for employees so that they can understand the policy and there's no room for confusion. We would also need to make sure that each and every time that there is an act of bullying and harassment, we follow the correct process. We follow a correct grievance investigation process, and as it says in the actual legislation itself, we need to take all reasonable steps to mitigate any of those issues. Keeping in mind, there's a thing as well called vicarious liability under this Act, and what that essentially means is, if, for example, two employees are bullying each other, or one employee is bullying another employee, and we don't do anything about it as an employer, the employer is vicariously liable. So the employee can make a claim against the employer for the exact same claim amount as they could against the other employee. So you need to make sure, as a business, that you're taking all reasonable steps. Just wanted to set out as well what exactly bullying and harassment can be. So bullying includes things like aggressive, intimidating, and humiliating behaviour, not just from management, also could be from other employees. Bad language and rudeness, teasing, practical jokes, spreading rumours, exclusion from team activities is a big one that we often see, And one that is very often not kind of taken into consideration is unreasonable expectations of work. So whether giving too much or too little, or withholding information of what they need to do, these kinds of things can be seen in the eyes of the Anti-Discrimination Commission, as bullying harassment. However, keep in mind that this doesn't necessarily mean that any of the following are going to be bullying and harassment. So genuine disciplinary procedures, proper performance management, constructive feedback, and directing employees how to do their work or to do their work, that's not considered bullying harassment. And it's also not something that an employee could make a stress claim from workers' compensation, from your workers' compensation insurer about. So it's important to make sure that those two are completely separated and make sure that we follow the correct processes if either of the cases happen. So we'll move on to contracts and policies. These are something that's really important, but we'll touch on the importance of those in a moment. What I first want to do is talk about what the difference between them is. So with contracts, employees that basically contracts are there to have enforceable terms. So these are legally enforceable terms, and it separates from policies because often you don't want to have the policies as legally enforceable terms. And if you do, what you'd want to have is have them set out in a way where you can amend it. And so policies we keep separately, and we don't need employees to sign these. Policies can include things like leave policies. So if, for instance, we want to have an employee, we want to require employees to bring in a medical certificate if they're on sick leave for 3 or more days. And then halfway through, we decide, actually, no, we want to have them bring in a medical certificate for 2 or more days. If we had that in a contract, we would need mutual agreement to vary that. We couldn't amend that without the employee's agreement. However, if it's in a policy, that's completely discretionary. As long as the employee knows the policy, we can go ahead and enforce that, as long as it's reasonable. So there's a big difference there. So the reason why contracts and policies are so important comes into 2 categories: managing risk and managing employees. How many people? I'll ask the audience. How many people have contracts in their business? Perfect. So it looks like a lot of people do, and that's great. That's really important. We've got to make sure that all employees have contracts, and we've got to make sure that all employees know what the policies and procedures are. The reason why we'd be doing this is for a few things. Firstly, it's going to be for certainty. And that's the most important thing here. It provides certainty around the obligations of the employee. The reason why this certainty is so important, I'll give you a couple of examples of cases that have happened to me. I even had one happen to me today. So under the award that you're covered by, if an employee is a permanent employee and they don't provide the correct notice for their resignation, for instance, if they have to give a week's notice for their resignation and they just resign without any sort of notice, we can withhold from any money that's due. So that's a term that's under the award that the P&Cs are covered by. What that means is we have to be certain that this is a permanent employee and not a casual employee. However, I had a case today where an employee resigned, didn't provide any notice, and is now claiming that they're a casual employee. We have to look at things like their contract of employment to see if there was any certainty. There was no contract of employment in place. They were paid above the award rate, so we can't rely on their award rate. They never took any sort of leave, and so there is a lot of ambiguity there, and we could face an underpayment claim purely because of that. That's one of our clients. So keeping in mind that certainty is a huge issue, and it's something that we need to really be reviewing there. So once we've worked out the certainty, and another thing too would be, for instance, paying employees above the award rate to incorporate things like annual leave loading. So if you are paying them above the award rate, you don't have an offsetting clause in your contract saying that this above award rate is there to offset any entitlement that you get. There's not enough certainty around that, and what that means is employees could make an underpayment claim for their annual leave loading. Another thing that it helps with is compliance, making sure that you're meeting your statutory obligations. A thing in Queensland as well, you need to release a Queensland information statement with every new employee that's hired. You can even be faced with fines if you've been audited and you haven't been issuing Queensland information statements. What that means is, if you can put something in the contract of employment saying you've been issued with this and you agree that you have been issued with it, really shows that you actually have, and you can just give it to the employees when you give the contract. So it also helps protect the business interests, post-termination restraints, confidentiality, use of company vehicles, things like that. It's great protection for you. It also helps manage employees. So it sets expectations by communicating the expectations to the employees and maximising the chance that the employees will meet these expectations. Most employees typically would want to do the right thing, but they don't necessarily know exactly what the right thing is. So if we can communicate this to them early on in the employee relationship, if we can get them to read and review the policies and procedures, if we can get them to read and review the contract and sign that one off, it really sets them down the right path and avoids bad habits forming. And it's also great for enforcement. So for those who don't want to kind of toe the line there, you have clearly set out their expectations, which you can point to if they don't comply with them, and if they don't follow these, we can go through some sort of disciplinary action for misconduct. So by setting that clear expectation, then you're in the best position to enforce them, and it's really going to help manage employees and manage those expectations and reduce workplace issues down the line. Okay, let's have a look at some key policies and work out how they can help manage staff and help mitigate risk. So I'm going to ask a question to the audience. How would you manage an employee or two employees took annual leave at the same time? It's one of those things that happens quite a lot when employees, or when we have a busy period, for instance, the start of the school term, or basically, what we'd be doing is, you're quite right actually. In this industry, under this award, employees can only take annual leave during the Christmas holidays. But there also is a stage where, if employees don't put in their annual leave request, you would have to try and create a date. You would have to give them notice, 14 days notice, for them to be able to take that leave. So what that means is you'd have to try and work out what the best situation for that is. What I probably should have asked is, how would you manage employees that have been taking excessive sick leave? So if employees are taking excessive sick leave, that's where things become a bit more of an issue. So these are all protected characteristics. Employees taking leave, annual leave, sick leave, these are protected characteristics. We can't treat them detrimentally for taking them and for raising this workplace right. They can make potentially a claim against the company. What we need to do is set out clearly exactly what the policies are. And we put this in a separate document. We wouldn't put it in the contract, we put it separately. For instance, if an employee is taking sick leave, we'd be saying you need to bring in a medical certificate if you're taking 2 days off, or something along those lines. So that we can, if an employee is taking multiple days off and they're not bringing in a medical certificate, we can clearly say that's unauthorized absence. You're not getting sick leave for that. Same with annual leave, making sure that we have the employees apply in the correct manner for annual leave, so that there's no issues down the line. There's no scrambling when that Christmas time comes and we have to force them to take annual leave. There's also safeguards that we can use in kind of the policies and procedures manual. Things like a code of conduct for social media. How would anyone here, this is a question for the audience, how would anyone manage if an employee put offensive posts about the business on social media? Spot on. Yeah, we'd be looking at giving them a warning, but we need to make sure that we can give them a warning based off the policies and procedures and the code of conduct that we have. So we need to make sure that it's clearly stepped out that even though employees are at their own, they're in their own private time, they still can't put things on social media that can affect the business. This is something that we need to step out because there has been previous cases where employees do things in their own time, and because we don't have a policy in place, we can't really go through disciplinary procedures to protect the company. And that's one of the major things there. It also has other safeguards as well that can protect kind of rights of search and confidential information. We also, very important, we'll need to set out grievance, disciplinary and performance management policies. Make sure that anytime there has been a grievance raised, anytime that there is an issue due to performance or conduct, that we go through the correct processes. Down the line, if we're looking to terminate, or if we're looking to terminate off the back of that, we can show that we followed our fair process. We followed the process that we've already outlined. We didn't just jump into this with going into it too fast and doing it with an unfair procedure. That will help mitigate as much risk to the company as possible. Alright, and then basically, how can we help at Employsure? So we'd be helping with anything that's easy to anything that's incredibly difficult, to be quite honest. So even simple questions: how much leave do I get? How do employees receive this? What's the best way of going through a disciplinary procedure? What's the best way of terminating an employee? How can I make these employees redundant? That's the best way of we can guide anyone through that process, and we can be able to assist further there. So what I'm going to be doing now, I'm going to pass it over to my colleague Sean. He's going to provide a little bit more information.
Thank you, Scott. I hope everybody appreciated what Scott ran through and the complexities of what can be involved in industrial relations. And that's where Employsure looks to provide support to the P&C so that they can navigate these issues. You probably are all aware of our advice-only support that we provide. That's the 550 plus GST for the 1-year membership. And what that entails is that you then have unlimited access to our advice line. Scott is one of our advisors. You may end up talking to him or one of our many other advisors scattered around the country. So what it means is that if you have any questions, any issues, anything to do with HR, you can ring us as much as you want, small or large, it doesn't matter. Oftentimes HR doesn't end up being a huge issue, but it can often start as a small issue. Oftentimes people don't know what to do, so they don't do anything. Never a good strategy. Always better to be able to have access to proper advice, which our membership provides to you. So you can nominate any number of people from within the P&C organisation who will have access to us. So that's something that you can decide. You can nominate as many people as you wish, and those people can then ring us as much as they want. So it could be issues around pay rates, how much to pay someone, leave entitlements, overtime, anything to do with that, or some of the more serious issues that Scott spoke about, things like bullying, harassment, discrimination, termination, and so on. All of those things need to be handled correctly, and that's what having access to timely, proper advice is designed to provide you. And we'll step you through the process. So the advice relates to everything to do with handling these issues. So it's not just advice, putting all of that in writing where necessary, generating any documentation, emails, follow-up documentation, sign-off forms, whatever's required to step you through the process. Oftentimes there's meetings, who can be invited to those meetings, protocols around them, scripts, talking points, so what to say, what not to say. If you're in a meeting, someone says something, you're not sure how to respond, just excuse yourself from the meeting. Get on the phone, tell us what they've said, we'll tell you how to respond, go back in and finish the meeting. So we step you through the whole process. So we get from beginning to end, without putting the PNC in a situation where someone can then lodge a claim against them through the Commission. But what we have found is that a lot of schools do seem to be lacking in the contracts and handbook that Scott was talking about. And these things are crucial because they do provide you with a proper legal foundation to then deal with the particular issue. And a lot of schools seem to have documentation of varying shapes and sizes, some quite old, and so on. So what we've done is reviewed our offering to PNC Queensland to include documentation. We've done this via sort of advanced memberships, if you like. So we have the advice only, which is the 550. And then for schools with employees from 1 to 5, there's a 1-year membership available, which is $1,500 plus GST. And then for schools from 6 to 10 employees, it's $2,500 plus GST. So what this allows you to do is get all your documentation set up correctly. And the way we do this, we have a field consultant contact you. They'll go through how your the businesses in the school run, and we'll be able to set up documentation specifically for your school. So we're not just providing generic templates that go to the same school one after another. All this documentation is done specifically for your school. Now, we don't do documentation for all the employees. We do it for all the different roles in the school. Now, there may be, 7 or 8 employees, 4 or 5 different roles. So we'll do contracts for all those different roles, and then a handbook with all your HR policies and procedures. And over the course of the 12 months, you then have unlimited access to us. So it allows you a 12-month period in which to get all of your documentation in place. And what I've noticed is that the roles within schools don't really change all that much. So once you've got it all set up, you've then got a proper legal foundation in place. So what you can then do is terminate that 1-year membership, and once all your documentation is in place, follow it up with an advice-only membership, which is the $550. So it allows you to get everything set up correctly, and from there, moving forward, it then allows you to maintain the membership and the advice so that if anything does occur, we can provide you with proper advice moving forward. Now, does anybody have any questions about any of that? And Scott, you might perhaps want to field these because they're not showing up on my screen. So maybe if you want to run through anything that anybody asks.
Yeah, I can see a few questions that have been left in these in the comments here. So first and foremost, there's a question regarding term-based employees and when they take annual leave. Yeah, essentially you're correct. They would need to be taking annual leave only during the Christmas holidays, but that's based on mutual agreement. So that's the default position. If the employee and the business otherwise agree to change that, then you can also change that. But you'll be directing them to take that annual leave during that time frame. There's also another question in here regarding can we put when they're supposed to take annual leave into the contract, and that's where it becomes a little bit more interesting. I would always recommend having that in the policies and procedures handbook. The reason I say that is because awards can change. So the award currently says that employees should be taking it during the Christmas period, but we've seen in the past awards change, and if this award does change down the line, we're going to be contractually obliged to make these employees take annual leave during this time frame. Even if we didn't want that, we need mutual agreement to vary it. That's why I'd always recommend having that one in the policies and procedures handbook. There's another question here regarding long service leave during during the Christmas break, there's no need to necessarily let the employees take long service leave during the Christmas break. It's not something that they're legislatively, kind of from a legislative perspective, that they're required to do. So there's no issues there. There's also, I can see here some questions. We have a principal that would like to meet with an employee, and should we allow that? We need to make sure that we're following the correct process there, whatever the case may be in that respect. And there's also a question here regarding who the PNC should have as a contact person. I'm not 100% sure how to answer that one. On behalf of the PNC. Right. I mean, it's a good question. It'll obviously be judged on a case-by-case basis. So yeah, I mean, I think that's all the questions there. Is there any other questions? Oh, there's another question I can see here. Are you able to help with a contract that should not have been written in the first place? That's a good question. So a contractual clause that shouldn't have been written in the first place, again, you're going to need mutual agreement to vary that. We could talk about ways about negotiating that out of the contract. So you would be kind of convincing the employee through negotiations not to have that in there. And if the employee can sign off on that, you'd be good to go. But not necessarily. There's no easy way to get that out necessarily. But we can definitely assist with helping you through that. Is there any other questions today? All right, I'm going to pass it back to Bianca from Redback to finalise this.
Thanks, Scott.
Thank you. So we just want to thank everyone for joining the webinar today, and thank you, Scott, for your presentation. If you haven't done so already, please fill out our webinar survey, which you will see on your screen now. We thank you in advance for your feedback and wish you all a pleasant afternoon.